Okay, good morning, everyone. It's good to be back in New Haven. I flew in this morning, so sorry I wasn't able to be here for shoppers. This is a continuation of the shir that we started 2 weeks ago on copyright. So I'm just going to give a very quick summary of what we spoke about 2 weeks ago and how today is going to be a little bit different from that. 2 weeks ago, I spoke about the copyright law that I'm most familiar with, which is the American copyright system. That's a system of relatively recent origin. All copyright law is pretty modern by legal standards because the technology to copy cheaply didn't exist until the 15th century. So we saw 2 weeks ago how different legal systems have responded to that, the European systems, the British system, and then the American system. And we talked about how Torah might have potentially its own copyright system, but that was a very theoretical, just a potential way of thinking about how Torah might approach the concept of a copyright system. Today, by contrast, we are going to talk about an actual case briefly that is being heard in secular court. But the focus of today is really going to be what would happen if that case or a different copyright case came to a base din. So it's not going to be what theoretically might Torah have as a system of copyright, but what actual principles of Torah would apply for sure and have been applied in copyright cases. So if you look at the source sheet to start with the inspiration for the notion of copyright here, if you turn over the page, you'll see there's a page that starts with the number 57. And on that page and the following 2 pages, this is actually taken from a complaint. Complaint just means that a party is submitting a lawsuit in court. This is from Jem's complaint against Rebbe Drive. And the images here, as the complaint describes, are images that Jem claims Rebbe Drive took from Jem's archive and distributed on YouTube and on Rebbe Drive's own website, on its app, and so forth. And if you remember from 2 weeks ago, those of you who were here, we talked about in the US system how the similarity between the original work and the new work makes a big difference. In other words, if it's a total copy, it ended up in secular court. They wanted to make a din Torah, but it didn't work out.
No. There is a din Torah, a new one. It's 2 young kids.
No, he's right. They tried to make this.
My own person must say, told me to pay the basement. They're not going to settle.
It's a different case.
The same, that's Rebbe Drive.
No. There is 2 young kids. I think one of them is going to get something. It's in secular. They're not in the basement.
I think so.
They
They tried to go into.
No. They're still in basement. They're not in secular.
I hope you're right. If you're right, then this will be even more relevant here. So we'll follow up after and find out. If they ended up based in, that's great. So one of the things.
Go to secular court if they never even went to basement. If Sharak Pialocha, you're supposed to do basement. אם זה לא עובד, הולכים לסקר, זה לא יכול להיות מה שאומר. They didn't even do basing בכלל.
Did you open to the 3rd page? Just look at the 3rd page, I'll tell you, because it's interesting what you're saying. If you look at this, Jem actually did submit these photographs in a secular court. So we're going to have to find out at the end of the day whether it's going to end up there and based in. Maybe they came back. I hope you're right. So these photographs show you the basis of Jem's claim, whether it's going to be in based in or secular court, that the images were copied, that the video was copied, and the caption was taken word for word. And so you can see how that forms the basis of a claim of something, that someone's intellectual property being copied and used without their permission. That's the claim. So I'm just going to mention one other case that ended up in secular court, but it's of interest here, which is that there was a case about the English translation for the Tilas Hashem Siddur. Merkus copyrighted the English translation of, I believe, Rabbi Mangel authored that translation. And Oitzer Sifli Lubavitch took the translation and used it in their Siddur. And that case ended up in secular court also. And Merkus won because it was taking word for word the translation. So at this point, I'm going to turn it over to Rabbi Prescott, and he's going to talk a bit more about what might happen and hopefully what will happen in Beis Din in Jem versus Rebbe Drive or any other copyright case.
So as I mentioned the previous time that we met, we had this year, we attempted to construct various models for copyright law through way of Talmudic precedent. By establishing various principles from the Gemara, we attempted to extrapolate some semblance of copyright law that mirrored in some ways secular copyright law. In that way, we did that in the way of the Beis Medrash, the yeshiva, the Talmudist, if you will. It was a theoretical exploration of various topics. We began by deconstructing what we believe intellectual property's core mechanics, and upon which we established precedent for each of them. So we presented two models. The first granted intellectual property the status of equity, the same way you would own your car, your house, anything else is the same. It's the same form of ownership that one can obtain over their intellectual property. The second model that we presented didn't grant intellectual property status of equity, rather gave a medium for creators to receive compensation for their work under the halachic principle of sweat of the brow, that they invested effort into something else and somebody else cannot then go ahead and take it without proper compensation. In this year, we'll review the second model, review various treatments that the poskim gave to similar cases of copyright law, and that were omitted last time, again, because last time what we attempted to do was a theoretical explanation. It was more of the style of the yeshiva. We were speaking about ideas and inferences. This time, as we mentioned, what we're going to attempt to do is, so to speak out what would happen if an intellectual property case came to a Beis Din. The various shuvas and rulings that would come up in the findings. So before any Beis Din rabbinical court, or really any court for that matter, is going to hear a case, the first thing they're going to do is really look through the records. See, historically, have there been any cases of a similar nature presented to a legal body, and apply their relevance. This is because, and this is what any Beis Din will do, and they'll refrain from using the model we presented last week, because in general, any paisik, any Beis Din, and any court will try to limit the precedent they're setting. Instead of doing what we did last week, was to construct a new model, they will try to bring various components of the case under the pre-existing halachic umbrella, other principles that already exist, and see if they could apply them to this case instead of constructing new ones. So the first case they'll examine is that of the Maram Padwa. From Meir Katz and Ellenbogen, in the year 1550, sets out to publish an edition of the Rambam's Mishnah Torah.
Where are you? What page are you reading from?
Not reading from any page. This is not the first printing of the Rambam's Mishnah Torah. The first printing was done some 30 odd years before by Daniel Bomberg, who is most famous for printing his edition of the Shas. And Meir Katz and Ellenbogen was actually under his employ throughout this endeavor. But after Bomberg's passing in 1549, he dies in 1549. Katz and Ellenbogen views this as an opportunity. Katz and Ellenbogen views this as an opportunity to go ahead and publish a new edition of the Mishnah Torah. Up until that point, Bomberg had a monopoly on Hebrew printing. He had licenses from the Pope and the Church to print Hebrew books and Hebrew texts in Venice. So Meir Katz and Ellenbogen sets out about this endeavor to print this edition with the help of a Venetian Christian by the name of Bragadini. Initially, it was along with another investor, Giustiani, but there was a falling out in the contract and their negotiations, and Giustiani sets out to publish a rival edition of the Rambam's Mishnah Torah, and often stealing and siphoning from Rabbi Katz and Ellenbogen's edition and his commentary on the Rambam. It's important to note, for relevance of the case and its application to later cases, Giustiani's intent was not only to take market share from Katz and Ellenbogen, but he was attempting to secure a monopoly on Hebrew printing at the time. Like we mentioned, Bomberg, up until the point, had a monopoly on Hebrew printing in Venice. And he had passed away the year prior. And Giustiani, what he's attempting to do is not only to take away market share from Rabbi Katz and Ellenbogen, but really to knock him out of the business, to take away his profit. And for that reason, he sets the price of his Mishnah Torah at 1 gold coin less to undercut any potential profits that Maram Padua would have. So upon this, Rabbi Katan Olenbogen petitions Rabbi Moshe Islis, the Ramah, to grant him exclusive license to sell the Mishnah Torah. So there are 2 points of interest when we examine Rabbi Katan Olenbogen's petition. One is that he writes to the Ramah, who is a rabbi in Poland, not to a rabbi in Italy. And two, the very fact that he writes to the Ramah at all. The Ramah at the time is 21 years old. He was just appointed to the rabbinate of Krakow. He's young, and this is his first tshuva that he ever writes. So the fact that he's writing to Poland is of interest, and the fact that he's writing to this rabbi in Poland is of even more interest. So the reason why Rabbi Katan Olenbogen is going to the rabbinate in Poland and not the local Beis Din or Rabbanim in Italy is because his goal is not to prevent Giustiani from printing. He can't do that. He's a Christian. He can't get a Beis Din to stop him from printing, but he wants to assure the Jewish market. And the market is in Poland. That's where the yeshivas are. That's where the institutions are. That's where the Rabbanim are. Katan Olenbogen himself is from Germany. He's from Ashkenaz, that region. And the reason why he chooses the Ramah, various pieces are brought. They had a correspondence prior to that, and they were also cousins. So he was hoping that he would not only get a favorable ruling, but the Ramah would come out strongly in his defense. So the Ramah's tshuva becomes famous for a different reason outside of copyright. It becomes famous because he develops a new interpretation of understanding, no Noahide laws. One of the Noahide laws is that the obligation to set up court, rule of law. The Ramah understands this to be applied to Choshen Mishpat, that a non-Jew is obligated to follow the principles that are set forth in Choshen Mishpat. And this has philosophical relevance, halachic relevance that are much greater and broader reaching than simply our case. But after establishing that principle that a non-Jew is obligated to adhere to Jewish civil law by way of their Noahide obligations, he invokes the principle of Asagas Kful. The Gemara Baba Basra, which we'll quote shortly, on Daf Aleph, speaks about a courtyard that has two entrances, and one person has a mill, has a store. So there's another person there's another entrance to the courtyard, somebody else can open a store. The Ramah says, and we see this, that legislation usually protects commercial rights for the consumer. Right? It's allowing for competition. Usually that's what halacha will allow. Halacha will allow competition and will protect consumer rights. But in this case, like you saw in that case, right, as long as there's equal access to the thoroughfare, somebody else can open up a competitive business. But the Ramah likens this case of Rabbi Katan Olenbogen's Mishnah Torah to a courtyard with only one entrance, and the original owner, the original store being at the end of the courtyard, and somebody else opening up a shop at the entrance, preventing anybody from entering the other store, garnering the entire market share and prohibiting anybody from really gaining access to the other business. So in this, he invokes it would be unfair competition. Secular court, I think, secular law has similar halacha, similar rulings, similar laws, similar principles, and by that way he protects Rabbi Katan Olenbogen's Rambam, issuing that Giustiani had illegally encroached on Maram's business, and ruling that everybody must purchase the Ramam's edition. So this articulation of the Ramah is lacking if you were to attempt to transpose it onto an intellectual property case for two reasons. For various mitigating factors, the main ones being A, the basis of the Ramah's ruling is the elimination of the Maram's profit. It's not his ownership or equity in his creation. It's simply that what Giustiani is doing is taking away his entire business. But most examples of copyright case don't eliminate.
Why would you waste this whole property?
No, he's cheaper. The same thing, cheaper. Same thing, cheaper. It's eliminating his entire profit share, the entire business. The store. He wanted to put him out of business. His goal was not to make profit out of the Rambam. His goal was simply to get the Maram out of the printing business. He would lower the price by a significant amount. It's not that he's guaranteed profit at all. He was simply there to kick him out, if you will. Taking all the business. The Rama used seven lines of reasoning to defend Rabbi Ketanol and Bogan. We presented the one that is most often decided in any intellectual property case. But that would be limited to cases where the opponent or the copier is totally eliminating the business. Also, it's important to note, although Giustiani did copy the Maram's commentary and some of his work, the case was not that of illegal copying. The case was of illegal or illicit business practice. So although there are some terms and words and ideas and concepts that will be floated around here in this case that are smooth intellectual property case, it is not an intellectual property case. It is a case of illicit business practice and unfair competition.
Because neither of them had a copyright of the Rambam.
Neither of them had a copyright of the Rambam, but the Maram could have claimed copyright onto his commentary, which the Ram's commentary is actually present in almost any Rambam that you will open today. You'll learn, you'll have on the bottom, you'll see citations to the Tur or various other Svarim of the time. That's the Maram's commentary. So because of that, and actually dealing with that issue of the Ram's commentary, Rama invokes another principle. The Gemara says that you cannot have a sefer Torah she'eini mugaf. A sefer that could have potential mistakes in it, you cannot keep it in your house overnight. The Rama says that being that Ketanol wrote a pirush on it, and he cited and corrected additions and words and sentences of the Rambam, therefore the Rabbi Ketanol's version of the Rambam is the correct version, and it is not only prohibited, you can not only prohibited to purchase Giustiani's edition, but you're prohibited to keep it because it has potential mistakes. This line of reasoning of the Rama on its own wouldn't stand, because again, the main purpose of Ram was commentary. It's really margins that you'll find every fourth or fifth page, and it's more a citation of other opinions than they're amending mistakes in the text. The Rama is just more bringing it as a smith, as an add-on to his other arguments that are articulated. So again, this is lacking, but this will be brought up in any intellectual property case. The next source, if you will, that will be quoted would be the case of the Chassam Sofer. The Chassam Sofer invokes Hasagas rule, similar to Rama, but he articulates it different and applies it differently. Illegal encroachment. The Chassam Sofer dealing with somebody, a publisher had printed a siddur, a nusach hatfila, a machzer, and somebody had illegally copied that, had used the setup, had used the formation of the formation of this machzer, and reproduced it without the original publisher's permission. So the Chassam Sofer cites, if you look in source 1, he cites the Gemara. The Gemara in Baba Basra and Daf Chaf Aleph says, we have a brayso in support of Hasagas rule. So if somebody, let us say a brayso is supporting this opinion, so if somebody sets up fish traps, a fisherman baits a certain area of water towards fishing, and another fisherman has to distance their traps the distance of the amount that a fish can swim. Tosfos and Kedushin cites from Rabbeinu Tam's father that this is after that water had been trapped. So the Sefer quotes this as a source that we see when somebody invests in obtaining a certain market share, even though the fish don't belong to the fisherman until after he's caught it, but if they have invested in drawing the fish there by placing traps, a fisherman cannot benefit from somebody else's investment. And that would be theft to a degree. So in the case where somebody had developed a computer program to go ahead and to copy it or to sell it or to derive benefit from it, even if we will not view it as equity, but the person had invested in it, and one is not allowed to garner profit from somebody else's investment. It's similar but different to the principle that we articulated last time we met out Sport of the Brow, that a creator has certain rights to profit share of what they create. So, sure.
That go on forever, or just like you said, you get time, you want to wait 5 years to guarantee. So what's the state of those amounts? Is it once you set your investment, the oil was yours, and no one, or once you guarantee that your profit rate?
So we spoke about this a little bit last time. I think it depends on this model. Let's say that for example, the Simcipher's model, he would have a right as long as his investment is out there in the market, as long as those fish traps are there.
Once you set it up, that's it.
You set up, you invest in it, you brought the market share, you created the market share, you have exclusive rights to it. It's almost as if you have an equity in that. You don't own, let's say, the computer code, but you own the rights to marketing the computer code if you created the market for it. So there's a similar precedent set by the Nob Yehuda about making a profit of someone else's investment. The case is the following. If you look at source number 3, it's the second page. The Nob Yehuda in Mishpat Madura Tinyana Siman Chafdalid says, Aldover Asher Nishalti. This is the question that you asked me. Ruvain Chibur Pirish Al Seder Nezikin V'Kachim. A certain Rav had written a commentary on the Mishnayos of Nezikin of Kachim. V'holach Eitzel Shimon Hamatfis v'nisfasher imoy v'sach yadua v'ad kol daf sheyatfis loy. Elu Hasheni Elu Hashnei Starim. In Pirush Rashi, v'toisis l'pirush al ha'machaber hanal l'mata. So he had commissioned a publisher to print for him a Mishnayos with Rashi and Tosfos' pirush on the side and his pirush on the bottom.
Why do you say it's Mishnayos? Rashi and Tosfos.
So
That's what it was.
What?
That's what it was.
So
It was a
what?
vanity project, probably.
So what?
It's Mishnayos.
Exactly, Mishnayos.
If you have Rashi and Tosfos, you don't know.
Yeah, but it's actually tastes was always nice. Probably. This guy wanted to publish his commentary.
Could be it's Mishnayos.
Eh?
Say them as they can be Kachim is Gemara also. So the reason why you would assume it would be Mishnayos is because the typeset. He put the pirush, you could say for two reasons. I think that's just how the truth is quoted.
I wanted to be the whole shots.
Yeah.
One who's that in his shots.
Yes.
Shots is the moment.
Okay. So the Rav go. So the Rav. So what happens is afterwards, this publisher, the way publishing it done, you would arrange the letters on a print board. You would coat it with ink and you would print it on a paper. And afterwards, they would remove the lettering and put a new lettering to the next page. So this printer didn't do that. This printer left it there, and he printed for the Rav. He gave the Rav the number of volumes that he had commissioned for printing, and afterwards he had removed the Rav's commentary, but he used that very same typeset to print a competing edition. And the Rav went to the Nob Yehuda demanding that the publisher compensate him for his loss. He wrote to the Nob Yehuda that he had generated the typeset by commissioning the publisher to create it, and with the publisher counting that you can't own a typeset. I created it. I can use it for something else. So the lady who said the publisher would be right if he had paid for it himself. If he had paid for the publishing and the Rav had simply just bought the volumes off of him, then the publisher would have an argument. He arranged the typeset, he can use it as he sees fit, There you counters, but in this case, what happened was the Rav commissioned the publisher to create a typeset. So thereby the typeset is the Rav's to a degree, even though he doesn't own the lettering, he doesn't own the ink, he doesn't own the paper. He has certain rights to something that is intangible, which would be similar to an intellectual property, right? And therefore he must be compensated. The Rav must be compensated for losses that he incurred by the publisher printing a competing edition of the Gemara.
Why is he lost? The Rob didn't lost anything. The Rob wanted to print his Pirush of the Gemara. He wanted, since he paid for it, so the printer should pay him. He should give him some money because he paid for it. But he didn't lose anything.
So I think
The guy had a chance. The guy printed the chance.
so. He said. Okay, so he says V'ton Ruben HaMechaber. The Mechaber argued. Ya'an shetash l'shem eschiros hamesadrin ha'isius hu hayan meshalim ve'ata lama Yehana Shimon misider ha'isius chinam.
Why should we have enough? My wall.
Yeah.
Commission. What's commission? Yeah.
I commission. Yeah. You can't. You are benefiting from my work, and I'm assuming the reason why the Rav had a problem would be because if there's another print of Mishnayos going around, he's going to lose, and that's what's evident from the Ramah, from the Noid Yehuda's Psak, is that part of it was that it was unfair competition. He had benefited from his investment. So, yeah, right. So the Noid Yehuda establishes. So under the Noid Yehuda's line of reasoning, if someone would go ahead and copy a computer program, the copier would benefit from the program, and which was created upon the investment of the producer, similar to the Samsatper, and it would fall into the category of Zen and of Zeh Chaser, or you, according to some understanding, you wouldn't even have come under that. It's simply having enough from my investment, and therefore the Noid Yehuda requires compensation. Quoting the Gemara that we quoted last time in Baba Basra, Hamakev es Chaveroi, somebody that builds 3 walls around somebody else's property, and somebody goes ahead and invests money in putting up a 4th, he has to compensate the creator for those 3 walls. So these are various shuvas, responsa, various halachic ideas that would come up in conversation in a Beis Din if they were to attempt to apply copyright law. Again, this differs in the fact that these are not new concepts. Unlike last time where we had new concepts, new ideas, new formulations. These are finding similarities between copyright violation and pre-existing halachas. It brings various aspects of copyright law under the halachic umbrella. And like we saw in the Microsoft case, when they went to Beis Din, the Beis Din issued a psak along these lines of Hana Mechaveroi, of Hasadas Gvul. Instead of articulating lines of reasoning of equity, they simply brought it under the halachic umbrella. And this will be the goal of any Beis Din of any court to bring the case under pre-existing halacha.
So I wonder if we can, and you're going to correct me if I'm wrong, I'm just going to try to give a sort of bottom line according to the 3 different precedents that you explained of what we would be looking for in a case. We could think about the gem case, though I don't think we have the answers to these questions, but we did it according to the Ramah, first case you gave, the Maram. We're looking for whether the person who copied was doing it in order to undercut the business of the original producer of the work, author, compiler of the work. If there's deliberate undercutting to take the first person out of business, then that would be that the Ramah found sufficient to encourage or.
That's subjective. But whatever Giustiani complained that I wasn't trying to put him out of business. I'm just most of those business.
But if he's selling, say, below the market price at a loss to himself,
Well, who says it's a loss? Who says
To
it's a loss?
charity.
Maybe just less.
Especially rapid drive, right? It's
The guy.
Who says it was a loss? Maybe just less
so it
profit.
could be that this is a hard approach to prove. That could be true.
That's like to prove that you're undercutting someone. It's a big borderline.
Yeah.
He was losing money.
So we,
Yeah, he was losing money.
we even we don't know that
Right.
for certain. But Giustiani wouldn't need to lose money. It would need to guarantee that the Maram who is selling a similar product, if not, would be unable to sell his product. Meaning he was cutting the Maram out of the business. Tasaga's full.
That's the difference between competition and driving prices down versus putting someone out of business. That's a different. You say it's all about intent. You're saying that Ramah is all about intent to undercut someone.
I think the impetus for the Ramah to write Tshuva and to extend his line of reasoning, to give it to such a broad reach, was Giustiani's malice intent.
But that's
but the
you can't prove that. That's the Maram's feeling. Every party is going to feel their way. But Giustiani can say very simply, "I'm not trying to put you out of business. I'm able to. My cost of the product is cheaper. I'm just creating competition, capitalism."
I think that's exactly what you would expect. The parties would
Right.
come
So
in.
you can't prove that the Ramah's, they're going with this line of reasoning that he's trying to put them out of business. And that would be, you're saying that would be what you have to look at if you're trying to undercut someone. That's a very hard thing to really find.
I think
That's
that
store
makes-
by the concert, you can prove. Monthly.
Yeah, I think there could be, and I don't know in a particular case, what it would require, but there are sometimes objective indications, like the comparison between the price the person's selling at, and they can show how much it costs them to produce. And if you see that they're selling at a loss and they're doing it in a way that's responsive to the competitor's price, then it looks like an objective indication of trying to drive someone out. You can never prove, but there are sort of implications of what's going on in someone's head.
With rapid drive,
Every business starts off operating at a
That
loss.
was, some of these,
they're not there to make profit.
Right. So it'd be very hard to prove in that case. Let me try to do for the other two quickly, and then obviously there's a lot to bat around here, which is great. For the Sam Sefer, instead of looking at undercutting necessarily, we'd be looking at whether it's benefit from an investment that someone else already established in a particular area. In other words, if someone created a market for something by investing in a particular way or particular area of doing something, and someone else comes along and hops on and takes advantage of that or cuts into that existing investment, then that would be the basis for that claim. And third, again, I know these are not satisfying to those who would want to see it go back and forth, which each case would, but just as a basic. The third potentially could be if we take the view that it doesn't even require the first person losing, the third view of the Native Yehuda, that so long as there was an investment in the creation of the initial product, if someone is copying in a way that doesn't pay a commission back to the creator or compiler, then that in itself could be sufficient.
Good. There are stipulations within Yehuda because the concepts that he invokes are both cases. If you look in the Gemara there, where the copier, in this case, the copier invested financially in obtaining what the producer produced. So we view that financial investment as indication of their hana. But if they would just obtain it if they could just obtain it for free, there's nothing to obligate them. There's nothing to pinpoint. You would have paid for it. You took from me. You can simply argue back. I took it because it was free. I would never pay for it. Somebody illegally downloads music. You can't go. The producer would attempt to go to them. You owe me whatever is $1 for the song. And they would counter. I downloaded it because it was for free. If I had to pay for it, I would just listen to YouTube. With the problems that come along with that, but I would never pay $1 for the song. I took it because I just had to click a button and I had it on my phone.
Is it possible to say that some Sefer and Ben were concerned with people not publishing Svarim anymore?
trying to fit legal arguments type of that. Like they were more concerned if you do this, no one's gonna publish smart. I'm not gonna smart. They're trying to fit legal arguments type of that. Is that possible?
So that comes up in the Slavita case, the Slavita Gemara against the Vilna Shas. One of them had license to print the Shas for 5 years, and had a rabbinic license to print the Shas for 5 years. And after 3 years, they had completely sold out. So they had intended to print another edition, arguing that our license is for 5 years, and therefore we have exclusive rights on printing the Talmud. We're going to print another edition. Whereas the competitor argued the entire reason for that licensing that the Chacham had given you was so you can make your money back on your investment. You made back your money. So we have rights to now print a competing edition. And the 5 years are not 5 years. Those were just the assumed amount of time that, based on at the time, it assumed that it would take you to obtain compensation for your investment. So this is a famous case. And when
they printed their own shots. They didn't copy.
no, they printed their own shot. Oh, so when the case came to the Shvus Yaakov, when arguing these two factors, there was a gzeira, but there's a tam mitten like gzeira. The Shvus Yaakov says that since whenever we're dealing with printing rights of Sfarim, we are always driven. There's a mitzvah to print Sfarim. So he quotes the Rosh. The Rosh, when he came to Spain, found that everybody was wearing tzitzis, had wool tzitzis, with the strings have to be wool, on garments of Pishtim. The Gemara says that Beis Shammai had made a gzeira not to wear tzitzis with big day Pishtim, because you might come to be over shatnez with tefillas. And the Rosh was very perturbed by seemingly everybody in Toledo was going against the Gemara of the Mishnah. So the Rosh, in defending the people of Spain, writes that the reason for the Gzeira of Beis Shammai was you might become over an Isser. But that Isser was by having Tchelas, but since you don't have Tchelas anymore, so the Makkah Mitzvah, the Batal Hatam, Batal Gzeira. So the Shvus Yaakov says over here, the Makkah Mitzvah, Batal Hatam, Batal Gzeira.
But Sfarim is Eis Lasis. It's not a mitzvah. It's a current.
So the Shvus Yaakov viewed it as a mitzvah to have more Torah, to produce more learning. So when there's Batal Hatam, meaning when the reason is no longer apparent, that to protect, in this case, the reason was, the Gzeira was 5 years, but the time was to protect market share, to protect investment. So therefore, once they recouped, you can print again. That was his argument. So similarly, in these cases, you can argue, we see that there are, some Sefer says the reason why we granted, so you can, this would come into play, that there is a Makkah Mitzvah. So Makkah Mitzvah would have other reasons when there's no profit loss, or whatever, however you can articulate it. The Sam Sofer also presents a line of reasoning, or really the Shalom Aleichem fully articulates that the reason why if you look at the printing bans, they're all printing bans, they're not printing rights. Why is that? So the Shalom Aleichem argues because of this. They didn't want to limit Torah, they wanted Torah to be published as freely as possible. They also know that investing was a great expense. So therefore they gave years, even though it should be an equity, right? Even though it should be property, but we gave years so that it should expire at a certain point. But it does come up to play in various printing cases of copyright cases or similar cases that Torah does influence our psak. Similarly, I think in secular or similar, you have fair use doctrines that are there to promote creativity amongst artists, to balance investment and creativity on the other hand. So similarly in Torah, you have a balance that has to be played, a line that has to be drawn between new chidushei Torah, new svarim, new printings, and protection of people that had printed to encourage them to print again.
We are over time for the scheduled length this year, but obviously there's a lot more to go on here. So I just want to formally conclude and thank everybody, and then we should continue for as long as everybody likes.